Oh, good evening, everyone. I'm delighted to welcome you to another event in our What Lies Ahead with Brexit series. I'm pleased with the engagement generally by colleagues, by students and staff, and equally importantly, by our local community. Let me just start by explaining that one of the key aims of this series of lectures, of the series of public debates, is to bring the university and the experts in our think tank closer to our local community. I mean, we know that we in university are sometimes seeing us being in our ivory towers, unconcerned in what happens out there, left in our own devices to enjoy the inherent calmness of the world of theory. Perhaps we are challenged every now and then by perhaps slightly controversial review of our work, and so on and so forth. And I'm sure that part of this is in a way true. But we must also now take note of a culture change in universities, partly caused by external factors. So you have research metrics evaluating the impact and relevance of our work. But also, importantly, this culture change is partly coming from within, with a new focus on impact and community engagement, answering some of the academics' prayers for a more direct role in influencing the political, economic, and social realities around them. So this is the institutional and cultural context in which we could perhaps place this series of events. This series aims to bridge the gap between the university and the local community, and Brexit offers an ideal platform for doing that. This is mainly because Brexit has brought to the surface, more emphatically than ever before in recent times, a worrying disconnect between academia and the public. We can take the example of our own university, deeply European and cosmopolitan in its orientation, and yet Hillingdon was one of the only 5 boroughs in London that voted for Brexit. So it is specifically around Brexit that we need to transfer knowledge to the community on the one hand, for example, attempt to provide the evidence basis required for the discussion of some of the controversial issues surrounding Brexit. And immigration is the perfect illustration here, as there appears to exist troubling misconceptions about the exact impact of migration on the country. And passions, of course, are running high, as immigrants are often seen as antagonizing, economically, socially, culturally, those that were here before them. Interestingly, this competition is even fiercer where the new generation of migrants battle it out with others who have migrated here before them. The referendum vote from Southeast Asians, for instance, was massively for Brexit. So we want to share knowledge with the local community, but we also want to learn from them. What has driven so many of them to vote for Brexit? Was it anxiety for future survival in an ever-increasing fight for resources in a changing world around us? And if yes, why was this anxiety channeled specifically towards the EU? And is there any evidence to suggest that those who voted for Brexit, in particular, will be better off at the end of the day outside the EU? I think this is where Jonathan Porteous' exciting work on immigration comes into play. And I must thank you, Jonathan, first of all, for accepting to be our key speaker tonight. We know Jonathan's a very busy man. He's a prolific commentator on immigration issues. His writings feature regularly in the Financial Times, The Guardian, The Independent. Last week, I believe he was at the House of Lords giving evidence to their EU committee. Jonathan is a research fellow at the National Institute of Economic and Social Research and a senior fellow at the ESRC Britain in a Changing Europe. And he was, importantly, previously chief economist at the Cabinet and 10 Downing Street. Now, Jonathan has recently been focusing considerably on the impact of Brexit on migration. I understand that his research indicates that as a result of Brexit, migration will indeed be reduced. Then he uses this as basis to evaluate the impact of reduced migration on the economy and reaches some very interesting conclusions. I won't say anything more about his argument and will keep you in relative suspense here. I will simply make an observation that could be used as an afterthought that could perhaps trigger some further discussion. That the impact of reduced migration does not manifest itself just at an economic level, but perhaps more importantly at a cultural level. In other words, what will the UK society look like if the Brexit promise is delivered and immigration is significantly reduced? Will some of the existing diversity be lost? Will there be an impact on the global city that London is, for instance, London as we know it? And even more critically, what's in reduced immigration for those who have long been convinced that we needed to act urgently in order to reduce immigration? Since evidence suggests they will not necessarily be better off economically. A potential second area of interest for today's event that we could locate in Jonathan's recent work, if I understand it correctly, is what will happen to EU citizens in the UK. And I have to say here that our think tank has called upon the government, I said that before, I will reinforce it here, immediately after the referendum, we called upon the government to unilaterally recognize full rights for all EU citizens currently in the UK. We feel that the government would thus reclaim the moral high ground and win hearts in the forthcoming negotiations, European hearts, that is. But the opportunity was missed, as a recent article in the Financial Times explicitly recognized. And this was after Theresa May's Berlin visit and the flat rejection from the German Chancellor's part to negotiate an early agreement on the rights of EU citizens in the UK and those of UK citizens in the EU. Now, Jonathan's recent work brings a much-needed pragmatic perspective to this crucial issue. His work is fully demonstrating the serious administrative issues involved in establishing who was and who wasn't lawfully in the country at the time of the referendum, for instance, if we were to take this as the key criterion when deciding a cut-off date after which EU citizens coming to the country will be subjected to the restrictions that would come into play with a new immigration, stricter immigration system. I think he speaks of a bureaucratic nightmare, which I think fully resonates with the complexities inherent in this process. So, a big part of this event will be concentrating on these highly significant issues relating to immigration. But before we engage with these issues, we will be looking at some of the key questions raised at the Supreme Court in the Miller case, the appeal to the Divisional Court judgment, which found that the government could not trigger Article 50 through the royal prerogative itself, and that Parliament needed to have the final say. The debate seems, in a fascinating way, to have captured the imagination of the country, to the extent, of course, that this is possible when we have legal proceedings at the appellate level, raising intricate, highly technical issues, and all this via the medium of a very idiosyncratic legal process that looks nothing like the Crown Court drama, for instance, that the public might be used to from popular fiction. Our own Professor Abimbola Olowofoyeku, head of our law school here between 2004 and 2009, originally and more recently between 2013 and 2014, and an eminent authority in constitutional law issues will explain all that, the legal dilemmas the Supreme Court is faced with, the key constitutional law principles at stake, and he might even risk a prediction about the final outcome. This remains to be seen. Well, I'm sure he will also be asked about whether the outcome now matters, as Parliament has now agreed to have a vote on the trigger. But I think he has a very good response on this, judging from our long conversation this morning. So Professor Olowofoyeku will provide an expert's view on all this. I will just make a quick observation here that regardless of what the outcome in the Miller case is, we are now witnessing a constitutional law revolution in the making, in the sense that the UK Supreme Court emerges from this case as the supercharged constitutional court we have never quite had in this country. Miller has launched the Supreme Court so powerfully into the life of the country that it is fair to say that the Supreme Court is here to stay, and that it is likely that it will claim a very central role for itself in the constitutional genesis. It is very likely we will experience as a result of Brexit. And as a result, of course, of striking to oblivion 40 years of EU legislation. An external judicial oversight as well in the form of the Court of Justice of the European Union, for instance. And I dare say the Supreme Court may be rejoicing that it is now emerging as the institution that will need to fill in this gap. Of course, it may have brought a huge challenge upon itself of being the institution that will have to stand up to the executive and provide indispensable judicial oversight. Now that we will not be able to rely on external judicial oversight for that purpose, certainly not from the Court of Justice of the European Union, but who knows, perhaps the same will apply to the European Court of Human Rights if the government proceeds with the previous plan to move away from the Convention. I will quickly conclude by noting how delighted we are to also involve in our event today's student panel. And it is hugely important to hear from them. And so we are starting to do this today with hearing from two students who come or are closely linked with from EU member states. We have Martina Kaloi, first year law student, one of my criminal law students as well, public law student of Bimbos. And she comes from Italy. And I believe she has only recently arrived in the country, precisely for the purposes of the degree. So it would be very interesting to hear what is her reaction to all this. And then Natalie Canning, in her third year of studies here, who I understand comes from Denmark, but is also very closely linked to the UK as well. So our students will be expressing some thoughts about how Brexit might affect their generation and what it means for them that the UK has voted to leave Europe. So I'd like to stop here and invite Professor Olowofoyeku to provide an analysis of the Miller case. Thank you.
Evening, everyone. This evening, I'm going to talk about the Article 50 case, and which I think shows UK constitutionalism in action. I'm first going to start with highlights of the Divisional Court's decision in Miller case. I have read all the submissions by all the parties before the Supreme Court, and that's quite a lot of reading. There are about 11 different parties that have made submissions. Some of the submissions are 60 pages long, some are 50, some are 30. I think the shortest is about 12 pages. And I've tried to distill all of that and find out what the issues are that they are raising and which the Supreme Court has to decide. And I'm just going to, first of all, talk about the decision of the Divisional Court, and then I'll talk about what the issues are from everything I've read. I am not going to be prescriptive. I may hazard a guess as to where I think the Supreme Court will take this, but we'll see how we go. So the Divisional Court's decision. The Divisional Court held that the Crown cannot use royal prerogative powers to invoke Article 50 of the Treaty on European Union to start the process of withdrawing the UK from the EU. In doing so, the Divisional Court applied a long-standing and settled principle that the Crown cannot, by an exercise of prerogative powers, change the law of the land. Article 50 of the treaty prescribes a process whereby a member state of the European Union may withdraw from the EU in accordance with its own constitutional requirements. And that's the issue before the Supreme Court, the constitutional requirements of the UK. The period for a countdown, once the notification has been given under Article 50, is 2 years, and to reach a deal. And if at the end of that period it is not extended unanimously by the remaining 27, then the UK will automatically leave the EU. And so the question is, or before the divisional court, was can the Prime Minister, exercising prerogative powers without regard to Parliament, trigger a process that will inevitably, one way or the other, lead to the UK exiting the EU? One of the main issues before the divisional court was whether an Article 50 notification could be revoked. And it was common ground before the divisional court that such a notification will be irrevocable. Now, given such an admission, it's not surprising that the divisional court reached the decision that it did. It could hardly have reached a different outcome. Now, the government has appealed against this decision to the Supreme Court. And I'll just talk briefly about the issues in the appeal. First of all, what it is not about. The appeal is not about whether Brexit happens or not. I think everyone is clear about that, and the parties before the Supreme Court are clear about that. It is about how Brexit happens. That is, it's about the withdrawal process or mechanism. And it may possibly, indirectly, be about which kind of Brexit we end up with. Now, the Supreme Court is not going to decide which kind of Brexit we end up with, but an indirect outcome of its decision may be to determine that, because if it's up to Parliament, then we may get a different Brexit from what the government would like. The specific questions that arise are, first, which branch of the state, that is the executive or the legislature, has a legal and constitutional right to make the decision that the UK will withdraw from the EU. That's at issue before the Supreme Court. Who has the right to actually make the decision that we are leaving? The government has announced that the decision has been taken, but the question is, by who? By unnamed people at an unnamed time without any reference to what the criteria are, other than we've agreed to accept the result of the referendum. And so it still remains a question: who has the right to make that decision that we will leave? Who has the right to accept the result of the referendum? Second, which branch of the state, that is the executive or the legislature, has a legal and constitutional right to give notice under Article 50? Third, is the legal or constitutional authority of that branch of state constrained by the constitutional structure of the UK? The UK is a union of formerly independent nations forged into a state by international treaty. Does this constrain the power of whoever has the right to make a decision or to make a notification? And fourthly, is the legal or constitutional authority of that branch of state constrained by the UK's devolution settlement? So those are the core issues that the Supreme Court has to decide. And the trigger for all this is, what are the UK's constitutional requirements? Because Article 50 requires or allows a member state to give notice in accordance with its own constitutional requirements. So the argument is all about what our constitution requires in this situation. Now, the Constitution of the UK, we have what we call the laws of the Constitution and the conventions of the Constitution. So the laws of the Constitution relate to parliamentary legislation, judicial decisions, and the royal prerogative powers. So first of all, I'll talk about the issues arising out of the law of the Constitution. Then I'll talk about issues arising out of the conventions of the Constitution. First of all, the issues arising from the law of the Constitution. The nature of EU law rights. That's a big question for debate. You'll find that in all the written submissions. We're told that EU law is ambulatory, and references to EU law assume but do not require membership of the EU. This is the government's position. That raises a number of questions. First of all, the right to vote at European parliamentary elections and the right to stand as a candidate. Surely These assume membership of the EU. In fact, they require membership of the EU. The rights under the EU Charter of Rights, EU citizenship rights, and of course the 4 freedoms. So the government's position is that references to EU law or rights under our legislation simply assume, but they do not require membership. The second issue is whether Section 2, subsection 1 of the European Communities Act, which incorporates European Union law into our law, whether it is just a mere conduit for pre-existing international rights and obligations to flow into and be given effect in national law, or are EU law rights statutory rights? Are they simply international law rights that are applicable here as a matter of bilateral agreement? Much will pin on the answer to this question, whether they are statutory rights or whether they are just international law rights that haven't acquired status as statutory rights within the UK. Now, just a comment on that. The rights and obligations apply in the UK only because Parliament has legislated that this should be the case. This was recognized in Section 18 of the European Union Act 2011. Now, Section 18 says that the directly applicable or effective EU law falls to be recognized and available in law in the UK only by virtue of the European Communities Act, which seems to undermine completely the argument of the government that these are not statutory rights, when we actually have a statute that says they are applicable here by virtue of a statute. And then another point that arises is the issue of incorporation by reference. Has Article 50 been incorporated into UK law by Section 2 of the European Communities Act? If so, does that matter? Has Parliament, via the European Communities Act, already given the executive the authority to invoke Article 50? That is, to cause a repeal of the European Communities Act itself by executive action. Does Article 50 have direct effect in the UK? Now, apparently the answer to this is no, because the government's counsel, leading counsel, James E.D. QC, he's said to have accepted that it is not of direct effect, and Lord Panic, for the respondents, also said it doesn't have direct effect within the UK. Now, Article 50 itself does not confer power to give notification. All it does is to recognize that notification is a matter for domestic arrangements of the state concerned. What are the limitations on the royal prerogative? This is a central feature of the appeal. Now, first-year public law students will know about royal prerogative. It's residual, it's legal, it cannot be enlarged. When it conflicts with statute, the statute will prevail. The prerogative cannot change the law of the land or confer rights on individuals or remove individual rights. The power to conclude treaties, which is a prerogative power, is this the same as the power to exit a treaty? That's a question that arises. Is there a prerogative power to make treaties or withdraw from treaties with automatic effect in domestic law? Now, the treaty-making power is subject to what is known as the Ponsonby Rule, which requires treaties to be placed before Parliament before they are ratified. This is now given statutory footing by Section 20 of the Constitutional Reform and Governance Act 2010. What are the consequences of giving notice under Article 50? Will it inevitably result in changes to domestic law? Is Article 50 revocable when you give the notification? Does it matter if it's revocable or not? It mattered before the divisional court, but it doesn't matter anymore because the parties all the sides are agreed that it's not material to the issues before the court. So there's not going to be any reference to the Court of Justice of the European Union on the question of whether Article 50 notifications are revocable or not. We're assuming that they are irrevocable, but in any case, it doesn't really matter. The outcome of an Article 50 notification would not by itself do anything to the European Communities Act. It's the government's argument. The next day, the act will still be in place. Of course, 2 years later, then something will change. The act might still be in place, but we will have left the EU. The government talks about a great repeal bill, which may retain or reenact some of the rights into UK law, but it's not going to reenact or retain all of them. Otherwise, why are we leaving the EU? But one thing that the Great Repeal Bill cannot do is to confer the 4 freedoms on UK citizens if they would like to exercise them in other countries, unless the UK remains in the single market. So some rights currently being enjoyed will be lost, and some rights, for example, the rights to stand as a candidate at European parliamentary elections or to vote, will be lost forever. So clearly, invoking Article 50 will cause some rights to be lost. Now, devolution is the next big issue that arises in this appeal. And this relates to the competence over devolved or reserved matters. So there are arguments about the Northern Ireland settlement, the Good Friday Agreement, the British-Irish Agreement. How do these impact on leaving the EU by executive power? The Act of Union with Scotland, is this an international treaty between Scotland and England? And if so, does it matter? Can the Crown change the law of Scotland by an exercise of the prerogative? There's no doubt that the law of Scotland can be changed by statute. But can the Prime Minister just go on the radio and announce we're changing the law of Scotland today, just by an announcement by the executive? Now, there are several arguments by the legal officers, law officers of the devolved administration, the Lord Advocate for Scotland. I'm not going to go into those arguments now because I can see I'm running out of time. I'll just talk briefly about the conventions of the Constitution. So the issues I've talked about are the ones that arise from just looking at the purely legal issues of the Constitution. We also have in the UK a convention of the Constitution. So even if governmental action is legal and valid, it may still be unconstitutional if it violates one of the conventions of the Constitution. So the question is, would invoking Article 50 by the executive or even by Parliament without the consent of the devolved legislatures be unconstitutional because it violates a constitutional convention? If so, would this be contrary to the UK's constitutional requirements? Remember, our Constitution consists of the laws of the Constitution and the conventions of the Constitution. And so is an unconstitutional but legal act contrary to our constitutional requirements. There's something called the Civil Convention that Parliament would not normally legislate with regard to devolved matters without the consent of the devolved legislatures. This was put on a statutory footing by Section 2 of the Scotland Act 2016. So it's no longer just a convention, it's now in legislation that you can't legislate in a matter that, in a way that involves devolved matters without the consent. And the arguments of the Law Advocate for Scotland is that many things will change in Scottish law, and devolved competencies will be affected by an exercise of triggering Article 50. Whoever is responsible for triggering it, it will still affect the law of Scotland and devolved matters, and therefore the consent of the Scottish Parliament is required under this convention. The government says it's a moot question. It is not justiciable. It is not enforceable. And then the question is, if something that can be overridden, if something can be overridden by Parliament, is this still a constitutional requirement when Parliament can just ignore it? Now, I'll just give you my thoughts, and then I will stop, and maybe we'll pursue some of this in questions afterwards. the European Union Referendum Act 2015. It provides for a referendum and states the questions to be asked. It does not authorize or mandate anything other than the holding of a referendum. That's all it says. There shall be a referendum. What happens afterwards? It does not stipulate what shall happen to the results of the referendum. It's advisory. It's not binding. It's not binding on anyone. Even if it could be considered binding because the background of the referendum indicated that the outcome will be definitive, and if it gives the government a mandate to fulfill the wishes of the electorate, it does not say anything about the manner in which the government must set out to carry out that mandate. It certainly does not justify the government using unconstitutional means. That is, the end does not justify the means. And we have in this country something called the rule of law, which we all subscribe to. The referendum was not about which kind of Brexit will happen. The electorate was not asked that question. The Prime Minister says Brexit means Brexit. This is circular and meaningless. Brexit means Brexit. Well, what does Brexit mean? And therefore, the meaning of Brexit must be determined by the electorate or by their elected representatives because they have not made that decision. It means that what Brexit means must be determined by Parliament, if not by another referendum. Therefore, the executive cannot go and negotiate Brexit terms or the meaning of Brexit with other EU states without a clear mandate as to what that meaning is. This is just my thoughts. The treaty-making power. The government talks about the treaty-making power being a prerogative matter, which is correct. However, treaty-making does not normally involve changes in domestic law because of our dualist approach to international law. And if treaty-making powers are to be used in a way that a change in domestic law is likely to result from this, then the exercise of that power is ultra vires the executive. Devolution. This is a very complicated issue. We can look at it from a purely technical legal point of view, parliamentary sovereignty. Parliament can do anything it wants to do as long as it passes legislation. So if there's parliamentary legislation authorizing invoking Brexit, then the devolved administrations may just have to suck it, and there's nothing else they can do. But what about the Sewell Convention, which is now in statute? The power of the executive. And then finally, the Acts of Union. Again, the orthodox doctrine of parliamentary sovereignty means that Parliament can legislate contrary to the Acts of Union if it wants to. That's the English point of view. But the question is, the principle of parliamentary sovereignty, is it an English principle or a UK principle? And of course, we've had Scottish judges saying that, including Baroness Hale in Jackson's case, saying that this is an English principle. That's been stated several times, and maybe the notion of the unlimited sovereignty of the UK Parliament doesn't exist in Scottish constitutional law, and maybe it doesn't exist in Northern Irish constitutional law. The Supreme Court will have to decide all these things. So this is a very big case. There are a lot of very complex issues, and the arguments, all the arguments sound convincing when you read them. And, but at the end of the day, will I hazard a guess? Yes, I'll hazard a guess, which is that the government will lose the appeal. Thank you.
Thank you very much, Bimbo, for a very penetrating analysis and for risking a prediction as well. That was very brave. But of course, it was based on a lot of evidence. We're running a little bit late, so we will quickly move to our student panel. If there are questions, I'm sure there are questions, but if you could kindly reserve them for the end, for our Q&A session towards the end of this event. So I would kindly ask Martina to offer some reflections on what Brexit meant to her.
Yes, as you heard from Dr. Dimitrios, I am from Italy, and what Brexit essentially means to me, it means a great deal of uncertainty, as it means for every other British citizen in here or EU national. But more than that, it means that an increase in popularity of the culture of exclusion here is probable, is a very present problem in here. In fact, I'm thinking back to the moment I landed in here in September, which is very recently. I was very rudely asked to go back to my country. So this means that exclusion is a real problem in the post-Brexit Britain and UK. But, however, it also means that the academic community can tackle this problem actively. In fact, just seeing from the lecturers in here and from the students, the culture of acceptance and tolerance can also overcome the culture of exclusion. And this is a very important reassurance that the academic community has given to EU nationals and students in general. And it is a reassurance that the government has not given to EU students and national. So this is very reassuring for me, especially reassurance coming from the professors and lecturers and other students, which have been very accepting. Thank you.
Thank you very much. Natalie?
Yes. What I'd like to mainly say are just purely opinions of myself, and Martina touched upon this about the confusion that Brexit actually caused, which I think is one of the biggest issues actually at hand, because Bimbo talked correctly about how Theresa May said Brexit means Brexit, but in reality no one knows what Brexit means. And to me, this is something that should have been clarified before even the referendum, and we all agree that David Cameron brought this up as a way to win the election, essentially, and then went forward with it. But in reality, people still didn't know what it meant, and people still voted on it. I have a big problem with how the campaigning of the referendum went forward. I think it was very irresponsible and dangerous, the way it went on. I found, actually, Demetrios said as well that Hillingdon is the only council that voted against Brexit, or one of the only councils in London. And I found, in my house, I was given something through the mailbox that had just pure lies about Brexit. And having studied EU law in the second year, I learned a lot of facts. And I read these things, and these were very basic facts that I knew weren't true. But unfortunately, not everyone knows this, and that's none of their fault, obviously. So I think David Cameron and Jeremy Corbyn had a responsibility, and all the others had a responsibility to explain to the public what Brexit meant before we got here. I feel now we're too late already explaining now what it means. Obviously, I fully support the fact that it's gone to the Supreme Court, that we need to decide how this is going to happen so that it hasn't just rushed into it. I also think it's very important that the effects that Brexit had and the confusion that was surrounding Brexit, the effects it had on immigration as well, which I've read a lot of articles written by Jonathan Porter, who will speak later, about who no one really knows whether they can leave or not. And Martina said that she'd been told to leave the country, and I've heard many different stories like that where people have been told they have to leave the country. And that's another thing where other politicians have said, and Brunel, might I add, have also said, those who are legally here can legally stay. But no one knows who's legally here, and no one knows what it means to legally stay. So I think all these questions should have been answered before we got here. And I feel like we're a bit too late now. And it's a shame. But I think they've taken a good turn on the Miller case. It's all over social media. It's live streaming on Facebook the past few days. And it's something that the younger generation is now heavily involved in, which is really good because we can make a change then, hopefully for the better. And yeah, that's all I have to say.
I see my colleagues from law over there smiling. I'm sure these are smiles full of pride, and I share the feeling. And I'd like to thank you very much on the behalf of everyone in the law school for being courageous enough and at the same time very critical, demonstrate great critical thinking, coming up and expressing these thoughts, which are invaluable, honestly, to the debate on what happens next with Brexit. We look forward to further interventions during the Q&A, but once again, thank you very much for your contributions. And with this, I'd like to kindly ask Jonathan to speak to us on immigration after Brexit.
Thank you very much indeed, Dimitris. Thank you very much for inviting me again to Brunel. I was here a couple of years ago to talk about Will Hutton's book with Vicky Price, one of my fellow economists and a fellow Greek emigre to the UK of long standing, and it's nice to be back. I'm going to talk about I'm going to talk about immigration and free movement after Brexit. I'm not, I mean, as we said, I'm an economist. I've written quite a bit about the economic impacts of immigration and free movement. I will say a bit about that, and I'm happy to answer questions, but I'm not going to talk too much about that. I'm more going to talk about what the title of the presentation, what lies ahead, what's going to happen in this incredibly complicated landscape in which we now find ourselves. But before I do, I mean, one of the slightly paradoxical things that I found in the last few months is finding myself having to defend occasionally both the government and my former civil servant colleagues. As many of you will know, I've been a critic of the government both on general economic policy and specifically as well as on fiscal policy, on immigration policy. But to be fair to Theresa May and the current government, this mess is not of their making, and at least individually, some of them had a hand in it, but collectively, as a new government, Theresa May found herself Prime Minister unexpectedly, much sooner than she expected, and was left a legacy by Mr. Cameron and by the referendum, which frankly is quite difficult to deal with. And I mean, I think it is very understandable for people to say, well, we should have to criticize both for not saying before the referendum what Brexit meant, and for now just saying that, well, Brexit means Brexit. But if you think about it, it's not really as easy as that. There was no way that before the referendum we could have known what Brexit would mean. That is not how it works. Brexit will be the result of a complicated negotiating process with the European Union, interacted with political and economic developments in this country and in the rest of the European Union. That is what Brexit will be in the end. And to say that 3 months ago, well, the government or the Leave campaign should have said what that looks like, well, that wasn't possible. Brexit is to some extent a leap in the dark, and I think actually a lot of the people, now that arguably is a reason, or should have been a reason for not voting for it, at least for some people. But, and I'll say why in a minute, I actually suspect most, if not all of the people who voted for Brexit actually did know that they were voting for something of a leap in the dark. And perhaps for that was one of the reasons that in many cases some of them voted for it. And we should recognize that. It is undoubtedly true that the Prime Minister's statement that Brexit means Brexit is circular and meaningless. But once again, she is in no position at this point to say what Brexit means. She's not even really in a position to say what the UK government thinks Brexit ought to mean or what it wants to mean. And for reasons I'll come on to in a couple of specifics, it's incredibly difficult at this stage to even work out what Brexit will mean. This is going to be Brexit inevitable. I mean, there will be a date when we notify Article 50, presumably. There will be a date on which the UK leaves the European Union legally. But neither of those are Brexit as such any more than June 23rd was Brexit. Brexit will be a long, complicated, messy, and in some cases quite painful process, and that is simply the nature of the beast. With that preamble, immigration was a central issue in the campaign, perhaps the central issue in the campaign. But I think it's important to, before talking about the details of immigration, to look at things a bit more broadly, and think, why did, what was going on when we voted for Brexit? Let's see if I can get this pointer to work. Yes, there we are. This is from the Ashcroft post-referendum poll, 12,000 people, so quite a big and reliable sample, asking people why they voted the way they did. And the point here is the extent to which Brexit was about values, about culture, for good or ill. So basically, it is entirely true that if you thought immigration was a good thing, you almost certainly voted Remain, 4/5. Equally, if you thought immigration was a bad thing, you almost certainly voted to leave. 4/5 of people who thought immigration was a force for ill voted to leave. But it wasn't just immigration. The same sort of proportions, which you can see that the same sort of proportions are true for multiculturalism, for example, for social liberalism in general, even for feminism. Now, what does the European Union have to do with feminism? Well, a bit here and there, but fundamentally, how gender relations in this country manifest themselves is not going to be determined primarily by whether or not we're a member of the European Union. And actually, this isn't on this chart, a separate poll, but if you ask people whether or not they support the death penalty, that's an even better predictor. If you support the death penalty, you voted for Brexit, almost certainly. If you oppose the death penalty, you voted against Brexit. And that's really interesting, because the death penalty not only wasn't an issue in the referendum, it's not an issue in British politics. Even people who believe, the people who support the death penalty don't think we're going to reintroduce it. It's not on the political agenda. It's not going to happen. So saying you support the death penalty, in some sense, doesn't actually mean you support the death penalty in any meaningful sense. You're not going to go out and do anything about it. It is purely a signifier. It signifies, saying you support the death penalty signifies your values, signify where you position yourself within British, or perhaps in this case, English culture. And so remembering that a large proportion of the people who voted for Brexit were doing it as a signifier of something which may or may not have been directly related to the European Union, to issues like immigration, to the economy, I think is very important in this debate. So, on to immigration. And again, so why is immigration in particular seen as having this sort of impact? These are just the numbers. You can see this is the number of EU nationals and non-EU nationals in the UK labour market. And you can see there was quite a significant rise in the number of non-EU nationals in the 2000s. That sort of flattened out in the 2010s. But starting from 2004, and then again, particularly steeply from 2010, a very sharp rise in the number of EU nationals working here. And so there are now about 3 million there's about 2.2 million EU nationals in the in the workforce working, and 3 million EU nationals resident in the country, compared to maybe only about 1 million 15 years or so. That really is a pretty sharp rise. I mean, that is for the UK quite a substantial pace of change in the labour market, in society as a whole. This has been a big change for people. Now, what have the economic impacts of this been? And this, as I say, I won't say too much. You can read what I've written. But the basic point here is that while this has been a really big change, we have had a very, very large influx by historical standards of EU nationals into the UK labour market. The effects have been pretty positive, surprisingly positive. And if you had asked, I was the chief economist at the Department for Work and Pensions, working on labour market issues in 2004. If you'd asked me what impact the influx of such a large number of EU citizens working mostly in relatively low-paid jobs would have on the UK labour market, I would have said it would push up unemployment, at least to some extent for UK nationals, and it would push down wages quite significantly for low-paid people here. But that hasn't happened. It's just not in the data. EU migrants don't appear to have those negative impacts on jobs or even wages for natives. There are undoubtedly some pressures on local services as a result, and congestion effects, especially in places like West London, frankly, and you can see that on your streets or in your hospitals or GPs. And those are very visible, but equally, of course, migrants in work pay tax, and we know from a number of analyses that the overall impact at a macro level on both the economy and public finances is quite positive. And that tells you something in turn about the economic impacts, the impacts of reducing migration post-Brexit. So this are the numbers that the Office of Budget Responsibility produced just a couple of weeks ago. I'm not going to go through them, but basically, if you look at the line, these are the impacts on the public finances. In other words, how much is the deficit going to increase as a result both of Brexit and other factors? And the bottom line here is that lower migration, this line here, pushes up the deficit by about £6 billion a year by the end of the Parliament. Now, that is not a huge number, actually, in macroeconomic terms, but it's not a trivial number either. And I think the interesting thing is that it's almost as big as the number that comes from lower growth resulting from lower productivity growth resulting from Brexit. In other words, the OBR is saying that although a lot of the talk in the referendum about the potential negative economic impacts of Brexit was focused on the negative impacts on trade and losing our trade access to the single market, actually the potential impacts of reductions in migration on the UK economy are just as big. And this is supported by some of this international evidence. This is from something the IMF published just a couple of months ago, looking at the impact of migration on growth, GDP per capita, and productivity. Again, finding very large positive effects. In other words, the economic advantages for us of being a member of the EU are not just about being open to trade and investment. The first three of the four freedoms, they are also come from the economic impacts of being open to people, to workers. As Dimitri said, I published something yesterday doing some further and more technical analysis of the potential magnitude of these impacts, and they are indeed quite big. But turning now to what's actually going to happen in policy terms. I think there are three issues, or two issues which I'll focus on. One is the transitional question, which a number of people alluded to already. What happens to EU citizens already here? And I think, again, I am not defending the government's unwillingness to say that in principle it intends to allow people to stay. I think they've sort of done that, but in a rather cack-handed and embarrassed way, rather than simply coming out and making a sort of clear statement, which you described, which I would think be helpful. But that said, even if they did make such a statement, we have to accept that this simply will not end the uncertainty. The uncertainty and insecurity for EU nationals, for indeed their families, children, and their employers, is an inherent consequence of Brexit. It is not something that we can say, oh no, we never meant this to happen, therefore, they'll be all right. It's a necessary consequence. Why is it a consequence? We don't have a population register in this country. We know that roughly 3 million, maybe a bit more, EU citizens live here. We don't know who they are. That 3 million figure is based on a survey. It's a survey data. It's not based on actually knowing who those people are. We don't know whether people were in the country. It only takes a moment's thought to realize that the idea that, that saying, well, if you were here on June 23rd or before, then you can stay, is meaningless and vacuous. As it happens, I wasn't here on June the 23rd. I was in Italy. But nobody knows that. How would they know that? And I'm not obliged to report my movements to the government. I might show up on the passport scan going in and out, but that's pretty far from complete data. Equally, nobody knows whether Maria was here on June 23rd. I don't know whether you're here on June 23rd, but more importantly, neither does the government. And it's quite possible you have no way of proving it one way or the other. Hundreds of thousands of people won't have any way of proving it one way or the other. So in the end, we will allow the vast majority of people living here to stay, and we will come up with some form of process that allows them to register their presence and to give them some sort of rights. I think that is a political certainty. But that process will be complicated. It will require law, guidance, administration, computer systems, bureaucracy. It will take years, and lots of people will fall the wrong side of the line. And I mean both wrong side of the line in both senses. So in the end, we will end up handing out British citizenship to some people, frankly, we'd rather kick out, criminals and undesirables, because that's the way these systems work. Equally, we will end up giving permanent residence, or we will end up denying permanent residence and implicitly or explicitly deporting perfectly respectable, law-abiding, and otherwise welcome citizens of the European Union, simply because that is what any bureaucratic system, and believe me, I've spent a long time working in government on such, any system which deals with millions of people in a legalistic way does that. And again, this is an inevitable consequence of Brexit. It's not something that we can avoid. I wish it were, but it's not. What about a new system? I think the key point I want to make here is that there are two dimensions of a new system that really matter. There's one which is frequently talked about, which is from hard to soft, and one from open to closed. And they're not the same. They're actually rather different. You can have a hard Brexit that's open or a soft Brexit that's relatively closed. What do I mean? Well, by hard Brexit, I mean what we were promised by the Leave campaign, but they are not in a position to deliver, which is full equalization of rights between EU and non-EU citizens. In other words, we treat in future we will treat citizens of France who wish to come here just the same way we would treat citizens of Kazakhstan, we treat citizens of Bulgaria the same way we would treat citizens of India. That is what we were promised. That is equalization or non-discrimination. At the other end, what does a soft Brexit look like? Well, a soft Brexit might look like something not too different from what we have now. If we stayed in the European Economic Area, that means free movement. That's probably not going to happen politically. But you can imagine something that looks like free movement light, with restrictions on people only coming to work, people not, at least in principle, being allowed to stay unless they had a job, much tighter restrictions on benefit entitlement, perhaps some extra fees for EU national students who currently pay domestic fees, and perhaps some overall quota or emergency break, but set at a reasonably high level. So that would be a soft version. In between, there's a whole range of different options, quotas, other restrictions, sector-specific schemes. One already, there are many articles being written on what those should look like. But the key point I would make here is that, first of all, that's probably where we will end up, is somewhere in the middle, or at least that's where the government will want to end up. And second, that again, from the bureaucratic and administrative point of view, rather paradoxically, that's the most complicated option by a long way. Because a hard Brexit, if we just treat the Irish, Italians like Indians, well, we know how to treat Indians because we do it already. All we need to do is double or triple or quadruple the capacity of the existing system to do that. Equally, at the other end, free movement light, that's presumably relatively easy to implement. Anything in the middle is inevitably, again, going to be a huge administrative challenge for the UK government. The second dimension is open versus closed. And what do I mean? Well, again, Leave, at least some of the Leave campaigners said, well, one of the great things about Brexit and this new non-discriminatory immigration system is it means we can have more skilled workers from India or from Canada or from the US. We can have an open, liberal system, but it's one that means that only the people, the types of workers that we want to come will come. And that sounded very seductive to a lot of people. There's little or no evidence, I think. In fact, there's a lot of evidence that Theresa May positively doesn't want that to happen. But it is a choice in principle for, if not for Theresa May, for a future government. Australia and Canada effectively have non-discriminatory systems that are relatively liberal, at least as liberal as ours. So at least conceptually, there's a separate question about how open and liberal do we want to be in our immigration policy post-Brexit, separate from the question of whether or not and to what extent we retain preference for people coming from the European Union. And finally, I do want to make this point because I think it is a very important point, and it is almost always got wrong by people on both sides of the argument in the public debate, which is that ending the free movement of workers is not primarily about controlling our borders. Free movement will not be ended at Dover or Calais or Stansted or indeed on the Northern Irish border. It will be ended mostly in workplaces. What do I mean by that? I mean that we don't in practice control immigration of, say, Americans or Australians at the moment by stopping them at the borders. You can come in with an American passport, show your passport, be given leave to enter, usually for 3 months. We check you against a list of terrorists and other undesirables, but the number of people we deny entry is minuscule. So assuming that we have visa-free access for tourism, visits, etc., for business visits and the rest of it, for French people and Bulgarians the same way we currently do for Americans, Australians, Canadians, and quite a few other countries. We won't be stopping Poles coming at the border. They'll still come here the same way they do now. What we will do is the same thing that we do currently for Americans and Australians, which means that in theory at least, you cannot work legally in this country unless, in addition to your stamp in the passport saying you are allowed in, you have some form of work permit or other permission to work. Well, what does, it sounds like a slightly semantic distinction, but it's a really important one. It means that we will not be controlling immigration at the borders. It means we'll be stopping people from working legally. That means that the immigration enforcement system takes place in workplaces. It means that our borders will not, that will be not that much more controlled than they currently are. But there will be a very substantial expansion in the way that we regulate employment in the workplaces. That will require a lot, if it's to, that will also almost certainly lead to a rise in illegal working. It'll make life a lot more complicated for employers. It means quite a lot more bureaucracy. It means, contrary again to what some people on the Brexit side argued, that we're going to have a much bigger and more intrusive state in a lot of respects rather than a smaller, deregulated one. If you think about it, the transitional issue that I described before also interacts with this one, because in future, having a European passport won't be enough to prove that you have the right to work the way it is now, but there will be these millions of people who will have some form of indefinite leave to remain and the right to work. So employers will have to distinguish between these different types of Europeans in a way which they simply don't have to at the moment. Again, we haven't even begun, by we I mean the government, the civil service, the bureaucracy, haven't even begun to grapple with the complexities of this. How much economic damage will this do? Well, this increase in regulation and bureaucracy and the regulation of the labour market will certainly do some damage. Beyond that, just how damaging it will depend on how open or closed the new system is. And we're clear, I think, that Theresa May wants a relatively closed system, but there's still quite a lot to play for, and we still have relatively little idea of where we're going in the medium to long term. I'm going to stop there. This is a huge topic. I hope I've given some sense, at least, not just of the broader economic and political context, but of the sheer complexity of the issues that the UK is going to have to grapple with over the next few years. And just as a side, I'd also note that the same type of complexity is also present if you look at other areas of the Brexit debate. So if you had somebody here talking about financial services or about what a customs union actually is and what leaving a customs union actually means, you get the same degree of complexity, the same sense of the interaction between transitional provisions and the long-term arrangements. Brexit is something that's going to be occupying our energies, political, economic, administrative, bureaucratic, legal, for the foreseeable future in this country, for good or ill. So I will stop there. Thank you.